Hi, my name's Elliott Berry. I'm an attorney from New Hampshire Legal Assistance, and I'm here to talk to you folks for a little bit about the foreclosure process in New Hampshire. New Hampshire is one of, I think, 27 states in which there is no judicial involvement in the foreclosure process. We're called non-judicial foreclosure states, unlike I believe Maine is the closest one, where if the bank or mortgage company wants to foreclose on you, they have to go to court and get the authorization of a judge. Here it's a remarkably simple process that usually starts with a notice of default and acceleration, which the bank will send to the homeowner, telling them that they're in default on their mortgage. And in my experience, I think that notice will usually go out when the homeowner becomes about 3 months behind in their payment. It will notify the homeowner that they have 30 days in which to contest the accuracy of the claim default, or explain any other reason why the default should not lead to foreclosure. At the expiration of that 30-day process, the legal or statutory requirements kick in, which are simply these. The bank or mortgage company has to publish a notice of the foreclosure sale for 3 consecutive weeks, the first of which cannot be less than 20 days prior to the foreclosure sale. It has to be published in a newspaper of general circulation in the town or county in which the property is located. And of course, in New Hampshire, I strongly suspect that the Union Leader is the most common place that the foreclosure notices are published. But again, it can be any newspaper of general circulation in the town or county in which the property is located. In addition to the 3 consecutive weeks of publication of the foreclosure date and sale, the bank or mortgage company has to send a registered or certified letter to the homeowner at least 25 days before the sale is conducted. It is important to note that not going to pick up or not opening the mail or not going to your post office box to pick it up is not a legal defense to the foreclosure. That notice has to not only be sent to the mortgagor, that is the homeowner, but also to all lien holders or holders of second or third mortgages on the property, provided that those liens or mortgages had been filed in the Registry of Deeds at least 30 days, at least 21 days prior to the sale. The notice of foreclosure foreclosure sale has to include the date, time, and place of sale. The place of sale is always the home itself or the property to be foreclosed, unless the mortgage document indicates a different place. But in my experience, the foreclosure sale is virtually always held at the home being foreclosed upon. The most important thing that is contained in the notice of foreclosure, besides the fact of the sale, it's the time and place of the sale, is that the homeowner has to be informed that they have a right to petition the Superior Court to enjoin or stop the foreclosure sale. And the notice has to say that this right extends up until the time of the foreclosure sale itself. So I've actually had the experience of going to court, getting a temporary order enjoining the sale, and running it over to the auctioneer who was conducting the sale on the front porch of the property. I don't recommend that the homeowner wait that long, but again, it is theoretically possible to foreclose or to enjoin the foreclosure sale up to the moment that it occurs. The most interesting thing about this statutorily required notice of your right to petition the Superior Court to enjoin the sale is that it doesn't set forth any legal grounds required for the homeowner to establish before the court in order to stop the sale. A superior court is what they call a court of equity, meaning they can do that which it deems fair and just under the circumstances. It's very clear that the courts are getting a lot of these petitions in these difficult times, and I think, quite honestly, are a bit more liberal about granting the at least temporary order stopping foreclosures than they used to be. But obviously, the homeowner has to think hard about whether or not a temporary delay of the foreclosure sale is, number one, whether they have plausible grounds, and number two, is it going to do them any good? I mean, remember that if you get a temporary order, the court is supposed to give the bank or mortgage company the opportunity for a hearing within 10 days. So just because you do get a temporary order holding off the foreclosure, that doesn't mean that it's going to protect you for very long. And so the question is, well, what reason might you have? Well, obviously, there are a lot of people who claim many illegal and unfair and deceptive practices that have occurred around the handling of the initial foreclosure mortgage transaction, or in the people are claiming a lack of good faith and fair dealing, or worse, in the handling of loan modification efforts. There is a lot of things that people have to say that it might be a basis for enjoining a foreclosure, but the mere fact that you've fallen on hard times and can no longer afford it isn't going to get you an injunction, unless, and I think this is an important exception to what I just said, if you have fallen into a deep hole that is quite temporary, and if you can establish for the court that there is that a delay of a month or two would enable you to do something to reinstate that mortgage, to pay, get caught up, or get you well on your way to getting caught up. The court will certainly, I think, be comfortable if that which you're relying on to happen is a relative certainty. If you just got hired, you have a job contract that says, you have been unemployed for 6 months, and now you just got a contract that's going to pay you, $100,000 a year. That's something a court would be very, very interested in. And but on the other hand, if it's if your improved financial position is based on your belief that you're going to win the lottery, or that Santa's going to bring you a lot of money, that's not going to cut it. And obviously, the more things that you can point out that the bank or mortgage company did that was improper, illegal, negligent, fraudulent, the more fault that you can ascribe honestly to the foreclosing institution, the more likely it is that the court will intervene. I should also note that for those people, and I hope there's more than I think there are at this point in time, but for those who still have substantial equity in their house, I have been able on a number of occasions to enjoin foreclosure sales just on the basis that there is substantial equity, the home is on the market, and there's a reason to believe that it will sell soon enough so that the bank faces no risk whatsoever of suffering any loss because of the delay that gives you time to sell and recoup some of your equity. So that's another reason It's harder to do in the wintertime because homes don't sell that well, but certainly if your foreclosure sale is coming up in, say, in April, and you have equity that you're trying to protect, and a sale will enable you to do it, I think that's an ideal time to ask for that, to ask the court to enjoin the sale, to give you the time you need to get that home sold. You really ought to have a listing agreement at very least if you're going to attempt to do that. If you don't have grounds that can convince a court to hold off the sale, then there will be an auction held at your home, and an auctioneer will come out. In this recession, I think the vast majority of auctions end with the bank or mortgagee purchasing the property for the amount of the debt, I think is probably the most common. When that happens, or whoever buys at foreclosure, the homeowner does not need to vacate the property at the time of the foreclosure sale. The purchaser at the foreclosure sale has to give the homeowner a 30-day eviction notice directing them to vacate the premises in 30 days. Even at the end of that 30-day period, the homeowner doesn't have to vacate. The next step, if the homeowner is still in the property, is that the new owner, be it the bank or anyone else, has to file a landlord-tenant writ, which is an eviction action in the local district court. And the tenant doesn't, or I'm sorry, the former homeowner doesn't have to leave the premises until the court orders them to do so, which, probably be in another 30 days. It's important at this juncture for me to remind you, I think, of an important opportunity here, which is after the bank or whoever purchases the property at foreclosure, is often a good time to approach them, or when they approach you with an eviction notice, to talk to them about the possibility of what they call cash for keys. You're not mandated in any way, you're not obligated to do a cash for keys, but if you leave when the court orders you to, if you wait until that time, you leave with nothing. A cash for keys deal is a deal where they say if you agree to leave by a specified date and leave the home in a broom clean condition, we will pay you whatever it is they agree to pay you. I've seen them go as high as $5,000. I think $2,500 to $3,000 is more typical in my experience. They have no obligation to offer anything. You have no obligation to take it, but it might be a way of salvaging something rather than going through the eviction process, which again, from beginning to end, is probably a 60-day proposition. One more thing I probably would want to say about the eviction process, that there are some let me back up a second. At the end, whoever buys at the foreclosure sale is required to record the foreclosure deed within 60 days of the date of the foreclosure sale. And until the deed is recorded, the foreclosure deed is recorded, title doesn't pass to the buyer. And so, if your strategy is, or your need is, to stay in the house as long as you possibly can, it's important, once you get that landlord-tenant writ, that is the summons on the eviction case, you might want to check the registry of deeds to see if the foreclosure deed has been recorded. Because if it hasn't, you can argue that the new owner has not received title yet, and therefore can't bring the eviction action until they do acquire title. And if they acquired title, say on November 1st, but they brought the eviction action on October 15th, you may be able to have that eviction action tossed because they didn't have title at the time they brought the eviction action. I think other participants will talk about another very important opportunities to delay or sometimes prevent foreclosure altogether through using the bankruptcy process. But I think I don't need to do that for you right now. You should remember, though, that filing bankruptcy, whether it's under Chapter 7 or Chapter 13, will at least temporarily bring an immediate and automatic halt to any foreclosure process, whereby using the Superior Court, again, people are getting pretty good results, but there's no guarantee. A judge may deny a request at any time. If you're facing foreclosure and you would like legal representation, sometimes we at New Hampshire Legal Assistance are able to provide that assistance for you. You need to be financially eligible for our services. We're for low-income families and individuals, and believe it or not, there are a lot of people who are facing foreclosure who do not meet our income guidelines, but you're absolutely free and encouraged to call, at least to find out. We have a toll-free number, which is 1-800-562-3174. And again, if sadly you are facing foreclosure, feel free to call.